Okay, we good? No,
Yeah.
One more minute.
No, I've got 4:30.
Okay, great. Welcome, everyone. My name is Brooke Mohr. I am the Vice Chair of the Nantucket Select Board, and I'm your moderator today for this session. I wanted to introduce Jim Salter, who is the representative from the Short-Term Rental Work Group, Denice Kronau, the Chair of the Finance Board, and John Giorgio, Town Counsel, who are on our panel today. And also with us are Erica Mooney and Libby Gibson from Town Administration. And I think that's everybody. Also in the audience, we do have other members of the Short-Term Rental Work Group, and we will likely be calling on them for clarification or input. And I encourage them to raise their hands if they feel that they can add to the conversation as we go along. The purpose of this evening's meeting is twofold in my mind. One is to answer questions about town meeting process. I've had a lot of inquiries from people about just how does this all work for people who've never participated in town meeting before. And then also to review the short-term rental articles 1 and 2 on the special town meeting warrant. And in particular, to help the community understand what the impact on individual situations as well as the community at large might be from a sort of an, if the articles are passed, how are they operationalized? What will the changes be? How will it impact people's individual situations going forward? And so I'm going to, Jim, do you want to start and talk? Jim, why don't you talk a little bit about those, the purposes for the articles that the Short-Term Rental Work Group organized their thinking around? And I think that might be helpful from a general understanding for the folks who are with us today.
Absolutely, Brooke, thanks. We in the short-term rental group had a number of values that we were trying to put forward in the regulations we came up with. And they were all sort of leading to a balance of respecting the finances of existing Nantucket families, but also respecting the integrity of neighborhoods. So here's a few of them. I'll summarize these from the town warrant. But one was, which we thought was very important, was to protect the time-honored tradition of home rentals on Nantucket and preserve economic opportunities through short-term rentals for persons to keep their homes. This is to protect families that have relied on short-term rentals, and there's a big tradition on Nantucket, a decade-long tradition of renting out homes. We also wanted to avoid adverse impacts on the economy, including the ability to collect taxes that help the town. And both of those have to be with protecting rights. And then the three that I'll mention now have to do more with limiting or protecting, limiting too much STR activity and protecting neighborhoods. The first one is to prohibit additional corporate ownership. That is, after town meeting, if this passes, corporations will not be allowed to operate STRs to new STRs. We'll talk about grandfathering in a minute. We also want to discourage investment-only STRs. These are ones that might not be owned by a corporation, but might be bought by a person just for the purpose of making money off it. And we put in some regulations to work in that direction. We also want to help, if we can, reduce neighborhood churn. That's all the people coming and going on Saturdays, and we know that can't be eliminated, but just to try to help reduce it some, we thought was a good goal. And then if we can, to help limit the conversion of residential units to short-term rentals. This is a big concern for the town. Of town people we speak to, probably the biggest concern is prohibit corporations moving forward. And that's really one of the big ones we're doing, but also trying to protect the finances of families is another big one. And sometimes those work in different directions, but we'll get into that. Okay, so those are the main goals that we had. And then we set up a number of regulations that we think are respectful of existing families with existing STRs, but also respectful of neighborhoods. So that's pretty much the values behind what we did.
Okay. All right, great. Just as a where we're going with this meeting today, this is meant to be informational. It is not intended to be a preliminary discussion that we might see on town meeting floor as to the merits of the article or and so forth. So I'm going to try to keep things focused on helping people get clarity around the impact of these articles should they pass, and expectations for what might happen process-wise at town meeting. So I'm going to open the floor, I think, first for questions about town meeting process. Is there anyone in the audience that is unsure of how this all works and what might happen at town meeting? Okay, I see Scott Wilson. Thanks, John. I'm glad you're back. We lost you for a minute, just in time. Okay, I see Scott Wilson's hand up. Erica?
Can you hear me?
Yes, go ahead, Mr. Wilson.
So I understand that the select board did took the short-term rental working group's draft and changed it. And then the finance committee changed that. And so I'm kind of curious as to what the first motion, what will be in the warrant and how the public will see sort of what's on offer and what they're going to be voting on.
Thank you for your question. John, do you want to take that?
Yes, and Brooke, I apologize. I've had a power failure at my house. I don't know.
Oh, no.
Why. It's very foggy here in Chatham right now, so I don't know if that has something to do with it. In any event, so the warrant is the legal publication of the articles to be acted on at town meeting, and the warrant is always signed under the hands of the select board. So the warrant that was posted contains the changes that the select board made to the work group's recommendations. Now, in Nantucket, it is the finance committee that initially makes main motions, and the finance committee held a public hearing and decided to draft a motion that changes what the select board had included in the warrant. So the first order of business at town meeting, and I assume folks have been to a town meeting in Nantucket before and know that the moderator reads through all of the motions, which will be the finance committee motions contained in a printed document that will be available to all voters. And she will read just the article number, and anyone who wants to put a hold or call one of the motions just has to yell out call. And those articles that are not called will be voted on in a block. And then we will return to consider the called articles. So assuming that articles 1 and 2 are called, the first order of business, the motion on the floor will be the finance committee motion, which has the changes from what the select board included in the warrant. Now, once that motion is on the floor, any voter can make a motion to amend. And so, for example, with respect to Article 1, someone could conceivably make a motion to amend to return to the language that was in the warrant, which is, and for sake of expedience here, which is the select board's proposal, which if that amendment passes, then that will be what's considered by the voters at town meeting.
John, I'm gonna ask the question that people are probably wondering. What is the vote threshold for an amendment on amendments in general? And are they different on a 1 and 2? For amendments?
a motion to amend is always a simple majority vote. And that's true whether it's zoning or not. Now, Article 1, when it is actually voted on, requires a simple majority as well because it's a general bylaw. Article 2 is a zoning amendment. That will require a 2/3 vote for passage.
Okay, thank you, John. Are there any other questions from the attendees? If you'd like to raise your digital hand, Ann Duaz.
Hi, good afternoon. Thank you very much, Ann Duaz on Mill Street. Please, John, if you could help me understand a little bit better about the process of offering motions on the floor. My understanding, which may not be correct, is that it is not possible to offer motions that result in a warrant article that is more restrictive than the one that's on the floor. You can loosen it, but you can't make it more restrictive. Is that correct?
Well, not exactly, and I know that's typically what people say. But it's whether or not, when an amendment is made, the standard is whether or not the voters were adequately warned in the warrant of the subject matter that was the subject of the amendment. Now, I can tell you that the more restrictive sort of concept really comes into play when, for example, there's a warrant article to rezone 3 parcels of land. And then somebody stands up at town meeting and moves to amend that by adding a 4th parcel. Now, that would be clearly outside of the scope because the voters weren't warned that that 4th parcel was going to be the subject of an amendment. So in this instance, to try to make this as simple as possible, if, for example, somebody got up and made a motion to amend the Finance Committee motion on Article 1 by returning to the language that was in the warrant, that motion to amend would clearly be within the scope because it would be the same language as was proposed in the warrant itself. And I've already discussed this with the town moderator. And of course, the town moderator makes all determinations as to scope. And she and I agree that if there was a motion to amend to return to the language of the warrant, that would be within the scope and town meeting could vote on it. Now, I will tell you that the moderator has a practice or a requirement that that people submit proposed amendments in advance. And I would strongly encourage anyone who is thinking about proposing an amendment that you contact the moderator in advance of town meeting to get her take on it and advice. And she will most likely consult with me because one of the things we want to avoid is a complicated amendment that we're all just looking at for the first time on the floor of town meeting. And that's pretty much a recipe for disaster. But again, if someone simply wants to return to the language that was printed in the warrant, which, for lack of a better term, is the select board's proposal, then that would be a simple motion to amend to adopt Article 1 as printed in the warrant, if that makes sense, Ann.
Thank you.
Thank you, Ann. Any other questions about special town meeting process? Okay, seeing none, I think we can move on to any inquiries that might help clarify for those of you who are listening what the effect of the articles will be, I guess would be the way I would describe it, as proposed and motioned by the Finance Committee. I think we'll start there because that is what we will consider first on the floor on November 7th. Any questions? Specific questions?
Brooke, if I may, I could give just a very brief description of what how the finance committee motion differs than what's in the warrant.
I think that's a great start, and then we'll move on to questions. Thanks, John.
John,
Okay,
do
so-
you want me to screen share to show it?
Sure. Thank you, Erica. While Eric is bringing that up, though, there were basically two changes that the Finance Committee motion makes to what's printed in the warrant. There's been a lot of discussion about linking the Articles 1 and 2 together, and the Select Board decided not to link Article 1 to the passage of Article 2 on the belief that Article 1, whether Article 2 passes or not, would enact these regulations, regulating the operation of short-term rentals as set forth in Article 1. What the Finance Committee did was they inserted into Article 1 the same linkage language that's in Article 2, and the effect of that would be both Article 1 and Article 2 would have to pass and be approved by the Attorney General before either one takes effect. The Select Board motion, as printed in the, I should say, as set forth in the warrant, if Article 2 fails but Article 1 passes, then Article 1 would go into effect. But Article 2, in both the FinCom and the Select Board proposals, must be approved before Article 1 takes effect. I'm sorry.
John.
No, yeah, I'm sorry. I just misspoke, and I apologize for that. The way the Finance Committee motion now reads, both have to pass in order for either one of them to be effective. In the Select Board's warrant, the Article 1 can go into effect even if Article 2 is not adopted. But Article 2 cannot go into effect without Article 1 being adopted. So that's basically the difference. That's the first difference. The second difference is contained in subsection H. And if some of you may recall that I think the selectmen spent like 3 different meetings going through the articles, and they felt in Article 1 that in order to be entitled to the grandfathering protection, meaning that you could rent for the 9 changes of occupancy rather than being restricted to 4, they required that that your unit must have been registered with the state and the rooms tax paid in one of the 3rd calendar quarters between 2019 and 2023. So if you hadn't paid the rooms tax in those prior years, then you were not grandfathered and you would be restricted to 4 changes in occupancy during July and August. What the Finance Committee proposal does, which was a recommendation from the Planning Board, is that grandfathering applies, meaning you can have the 9 changes in occupancy in July and August, as long as the unit had a certificate of occupancy issued by the building commissioner by the date of town meeting, November 7th. So
Thank you, John.
I think it's fair to say that the Finance Committee proposal is a more generous grandfathering than what the select board proposed in the warrant.
Okay. Thank you.
Those are the two changes.
Okay, great. Questions? Scott Wilson?
So just like Article 1, Article 2 is going to start with the Finance Committee recommendation that they're both linked completely. If one doesn't pass, the other one doesn't pass. You have to pass them both. But that's
So
that's
Article 2, Scott, Article 2 is essentially the same in both in the warrant of the select board and the FinCom motion. Article 2 cannot go into effect unless Article 1 is passed. The difference is in Article 1, under the select board proposal, that can go into effect regardless of what happens to Article 2.
And
Denice?
also, John, thanks, Brooke. And also what the voters are voting on, Scott, is the planning board's recommendation, not the finance committee's, because it's a zoning article.
Correct.
okay. But I guess I'm just trying to figure out where the discussion on Article 2 is going to start. It's going to start with the same either way, I guess, is what you're saying, because the difference is in Article 1.
Right.
Well, Scott, and I'm trying to make this as clear as possible. So let's assume we debate Article 1 and Article 1 does not pass. Then what I would expect would happen is, rather than a positive motion under Article 2, there'll be a motion to pass over Article 2. And then we would go back to the drawing board for a future town meeting.
So I'm going to try to restate that, John, just to use some other words to describe it. So as the articles are proposed now, they are linked to one another. So if Article 1 does not pass, then the plan would be to not even consider Article 2 at all, because they are linked to one another. So that is the way the warrant is written currently, which differs from the version proposed, the original warrant approved by the select board, which would have allowed Article 1 to pass or not, or not pass. No,
I guess
sorry.
I guess
Would
it depends on
allow
how,
it to pass. Yeah,
I guess
and then
it depends on how Article 1 passes, right? If it passes, under the Finance Committee thing, then we have to go to Article 2. If it passes under the Select Board provision, then it doesn't matter if Article 2 passes or not.
But there would still
Okay.
be a vote for Article 2.
Right.
Article 1 can be voted irrespective of what happens to Article 2 under the select board's proposal. But Article 2 does not stand by itself. It is dependent on Article 1 passing. And that's true in both the Finance Committee and the select board's proposals.
Okay.
And I think the reason for that, Scott, is Article 2 is zoning. It would allow the STRs as of right in all zoning districts, but it's subject to the requirements of Article 1. And so if Article 1 doesn't pass, then Article 2, it theoretically could pass, but it would then allow STRs as of right with no regulation. And of course, that's been a concern. The select board did not want that result, so they included the linkage language in Article 2.
Right.
But not Article 1. So it's sort of the reverse, if that makes sense.
Okay.
Got it.
Thanks, Scott. I'm going to take Ann Duez's question. And you need to unmute.
Sorry. I think, John, you mentioned a certificate of occupancy, which was a change from the select board drafting of Article 1 to the Finance Committee drafting of Article 1. And
Correct.
I think, and you said that that is something that the building department issues. So as my understanding of that is any property on Nantucket that is going to be lived in has to have a certificate of occupancy. So as long as you had a certificate of occupancy before the date of the special town meeting, whether or not you have ever rented a smidgen of space, you would be grandfathered?
Yes,
So it has nothing to do with your history as someone who offers property for rent.
that's correct.
That's correct.
Right. Okay.
Thanks,
Thank you.
Ann.
My second question, if I can ask one, is
Sure.
I think I also heard you say, I can't remember if it was you, Brooke, or John, that the planning board recommended the changes to Articles 1 and 2. But I'm confused now because I thought that the planning board really only had anything to do with zoning, not general bylaws. So how does the planning board fit into a recommendation on the general bylaw?
Well, you're right. It's not well, the difference, Ann, is that before town meeting can act on a zoning bylaw, there must be a report and a recommendation from the planning board. If we don't have that, we can't even proceed with Article 2. So with respect to Article 2, the planning board's motion is to adopt it essentially as printed in the warrant. That does not preclude the planning board from making recommendations on other articles, but it's merely a recommendation. It has no legal effect. And in this case, I don't want to speak for the planning board, but I believe it appears to me that they felt that while they were recommending Article 2, they wanted to also provide a recommendation on Article 1 from a planning perspective, although it's not legally required because Article 1 is not zoning.
Thank you.
Thanks, John. Dave Iverson? Dave, you need to unmute. There we go.
Had a hard time finding the unmute button. I just wanted to address if it's appropriate the planning board's thought process on the comment. If it's appropriate, if not, it's fine. So it's up to you, Brooke.
I'm sort of betwixt and between in terms of, yeah, I think a brief comment on that is fine. Dave, go
Okay,
ahead.
yeah, I just it was the planning board's feeling that that it was only right to grandfather people that have, the town's position is that it's a legal use in residential areas, and to grandfather it means to preserve that right for people that have it, whether they exercise it or not. So whether they have never rented before, they still have that right. And that's what grandfathering is. And there was just a great concern that a right that people had was being taken away, and two, that it could result in considerable litigation. And that was our thought process. Thank you, Brooke.
Okay, great. I'm gonna take a comment from John Kitchener. And then I think we're traveling into territory that sounds like town meeting floor discussion. So I'd like to move us away from that after John speaks and really move more towards maybe asking Jim to go through some of the frequently asked questions that are currently posted on the website, and that might spur some further questions. So John, briefly, please.
Thank you, Madam Chair. Yes, just one brief comment. We talk a few times today about the select board warrant and recommendations. I just want to make it clear that 5 of the 8 former short-term rental work group members all agree that the select board version is better than the version that we presented to them. And it wasn't the select board just making changes with no input from us. In fact, there were 3 separate meetings, each of 1 hour or more, where the select board encouraged the former short-term rental work group folks, to discuss it with them. And after 3 hours of discussion, what came out of the select board, at least 5 of us feel was better than the article that we first presented. So just so anyone who might be thinking that the select board came up with this on their own, that is not true. Thank you, Madam Chair.
Thank you, John. I'm going to have Jim. Anne, do you have a different question? Is your hand up for something different? I guess. Okay, hand down. Great. Okay, Jim, if you might, why don't you start running through some of the FAQs for the audience, and folks, if these explanations of the impact of the bylaw spur any questions, please don't hesitate to raise your hand along the way, and I'll try to manage inviting people to ask their questions as Jim's talking.
Great, thank you. And just before I start, the whole idea behind grandfathering was to be fair to people with existing STRs who have based their family finances on them. And that's the reason why there's some existing properties are grandfathered and new STRs will not be grandfathered, and why there will be more restrictions on the new ones, which I'll get to. Okay, so let's skip down to where it says town meeting articles, because we've already talked about the zoning, etc. So here's one of the differences we'll find as we go through this. A general bylaw, the first one says how much of a vote does it need to pass? It only needs a 50%. Or a majority or greater in order to pass, whereas we'll see with the zoning, it has to be 2/3. And that's one of the questions we have to look at with the linking between them, but we'll get to that. Okay, now let's get to grandfathering. I've heard that the general bylaw features a grandfathering clause. What properties and or STRs are grandfathered in this proposal? Well, the description right there below it that you can read talks about the certificate of occupancy. Basically, it's saying if you owned a property by November 7th, 2023, that property, and it has a structure on it with a CO, that property will be grandfathered. That is the Finance Committee version that is moving forward as of now. Now, after that date, a property that is sold is no longer grandfathered, and new structures after that date are not grandfathered. So what does that mean? Okay, let's go into that. If my property is grandfathered as an STR, what does that mean about how I can rent it? Well, the status of being grandfathered confers the following: as many as 9 changes of occupancy in high season, July and August. That's what we're all used to if we do rent out an STR, as many as that. You may not rent it that often, you may rent it 5 times, but there's those 9 weeks basically. An owner, if you've been grandfathered, an owner may operate multiple STRs if all the properties are grandfathered. And again, we made that regulation thinking of families that have based their finances on having a couple STRs. We want to discourage that moving forward, but we felt we could not be unfair. We must be fair to people who have set up their finances. And finally, I think none of us on the group wanted to see corporations operating STRs. However, a corporation that is grandfathered may continue to operate an STR. That's partly for legal reasons, and again, partly for reasons of equity. And we've been told there's a thing called retroactivity. You cannot take away the right from one group and not take it away from another group. But now let's go to the next one. If my property is not grandfathered as an STR, what does that mean about how I can rent it? Well, in that case, you can only have as many as 4 changes of occupancy in high season, July and August. And the thinking behind that was to do 2 things with that. One, we're trying to discourage investor-only STRs. And we thought about it, we did a bit of analysis, and we believe that let's say a very wealthy person that wants to make money off STRs and they're buying a new one, if they can only rent it 4 times in high season, they may not be able to make enough of an investment to purchase that property, which hopefully will allow that property to remain available to year-round rentals or to year-round owners. Okay, second, an owner may operate no more than 1 STR, just 1 STR per owner moving forward if they're not grandfathered, obvious reasons, trying to limit that. And no corporations may operate an STR. Corporations are banned from operating STRs. And that's a value that we know is shared strongly throughout the island. We feel we're very fortunate in Massachusetts that Massachusetts has given towns the right to regulate STRs. We were told in Arizona, where the state legislature said towns may not regulate STRs, that in Sedona, for instance, 20% of the housing stock has been bought by multinational corporations and turned into STRs. This will stop that. We know that only about 4% of our current STRs are owned by corporations, but we would like that to stay there. Okay. Now, the limit of number of contracts allowed by the proposed general bylaw, we sort of went over that with grandfathering, but here's the thing. Outside of July and August, there's no limits on the number of contracts allowed. So even if you buy a new property, you can only rent it 4 times in July and August. You can rent it in the off season. Now, part of the reason for that is one of the reasons for the 4 per high season is to help limit the churn we talked about. There doesn't seem to be much churn. I know there's some, but in the shoulder season, but it's not nearly like what we have in July and August. I know I live on Back Street. We can now get onto Pleasant Street, which we can't do very well in July and August. Okay, so you have a grandfathered STR property, you sell it. How does that affect its availability to the next owner? Well, it loses its grandfathering, so they can only rent it 4 times in high season. And that owner, of course, can only operate 1 STR. Now, there are some properties that we felt should not be affected by our general bylaws. In looking at them, there were special instances and would be unfair to have these regulations on them. That's hosted stays and what's called cottage colonies, which is a quaint term. Hosted stays means the person lives in your home with you. Obviously, the person who's hosting a hosted stay is very concerned about keeping it quiet and is regulating it well. And then cottage colonies are like that little group of cottages that are rented out seasonally. We all know examples of those, and we didn't feel it would be fair to try to infringe on what they've been doing. Okay, now, I think we've already answered this next one. How many properties?
Jim?
Yes, I'm sorry.
Jim, I'm going to ask you to hold. We have a hand raised. Gail Walker, do you have a question?
Great.
Hi, now can you hear me?
Yes,
Hi.
go ahead.
Hi, sorry. Yes, my question has to do with what the definition of a short-term rental is when you're talking about all these restrictions on the number. And my understanding was that if these articles were adopted, it would just be adopting the definition of short-term rental that's already in the code in chapter 123. And I just wanted to get clarification on that, because under that, it says at the very end of 123, section 2, the rental of property for a total of 14 days or less in any calendar year shall not be considered a short-term rental. So does that mean if you rent something for 10 days, it doesn't count as a short-term rental under these articles? Thank you.
John Giorgio.
I'm going to have John Giorgio. Yeah.
So that sentence comes right out of the state law. If you rent your property for a total of less than 14 days a year, you still have to state, but you are not considered a short-term rental, and you're not, and you don't have to pay the tax. It has nothing to do with changes in occupancy. It has to do with the total number of days you rent your property. So, for example, if you rent your property for 1 week during the high season, that is not a short-term rental, because the total number of days you're renting is less than 14 days in any given year.
And if I may elaborate a little, that definition follows the tax code, which if you rent a total of 14 days or less in any taxed year, you are not subject to federal income tax. Typically, you are not subject to the short-term rental tax at the state level. So it's an exemption that has existed in the tax code forever about renting your property. And so the state followed and included that. But again, to clarify, it is a total of 14 days or less in a calendar year that exempts you, not per rental. Hope that helps. Okay, any other questions before I ask Jim to keep working his way through? Okay, go ahead, Jim.
Okay, so we already know this, that if your property, how many properties can you rent as an STR? If your properties are all grandfathered, you may continue to rent them as STRs until they're sold, or if they're passed to your descendants. However, if they're there's a legal term, John, I can't think of it, but then they are still grandfathered if they are inherited by someone. Now, corporations, can they own and operate an STR? Only if they're existing now. In the future, they will not be allowed to own and operate STRs on Nantucket. Now, there are some areas that sort of move slightly or somewhat in the direction of corporations, and that's what these next two questions have to do with. The term natural person is mentioned in the bylaws, in the general bylaws, and as John Giorgio will tell us, a natural person is a legal term, and as far as I can tell, it simply means a real human being. Now, where does that play into effect? It plays into effect in this next question, and I will read it and then maybe ask if it's okay, Brooke, to have John explain it more. Can a property owned by an LLC or a trust or an S-corp operate an STR? And the answer is yes, but only when every shareholder, partner, or member of the legal entity is a natural person, there's that term, as established by documentation provided by the applicant at the time of registration. Now, we tried to learn from a number of places across the country that have regulated STR successfully ahead of us. One of them was Palm Springs, California. They had this regulation in effect, and they said it does work. They are able to tell if an LLC is really related to natural persons or if it's actually a cover for a corporation. And the phrase "as established by documentation provided by the applicant at the time of registration," we borrowed with thanks from Great Barrington, Massachusetts, which put that into effect, last year, about a year ago, but it was just approved by the Attorney General of Massachusetts in December of this past year. And I was wondering if John Giorgio has anything else to say about that, since that's legalese that's way above my head.
No, Jim, that's you explained it perfectly.
Okay, thank you. Now, we may need to get to John on this one too. Are STRs allowed in a deed-restricted unit or an apartment or townhouse? And basically, unless they're grandfathered, STRs may not be operated in any deed-restricted unit or in an unrestricted unit in an apartment building or townhouse owned, operated, and managed as rental housing. And there are reasons for that. Is partly to protect the other residents of such a a dwelling place, but it's also because a number of those dwelling places do have regulations already about the ability to rent. And then, so should I stop there, Brooke, before I get to zoning, or would you like me to go on? I think, are you muted?
I am muted. Had some background noise over here. I just pause for the opportunity for anyone who has questions about those, the LLC part in particular. I think a lot of people are curious about. I'm hoping it's clear, but if it's not, please don't hesitate to raise your hand to ask for further clarification or a question about your particular situation if you would like to do that as well. So just encouraging public participation. I know a lot of people like to stay quiet and listen, and that's fine too. So go ahead, Jim.
Okay, and so I want to say, if I may do this slight editorializing, that we at the short-term rental group really believe strongly that we really want Article 1 and Article 2 to pass. We think Article 1 gives reasonable and sane and well-balanced regulations. And we know no one will agree with all of them. In fact, none of us agree with all of them. And we think what Article 2 does is it further establishes the right to rent STRs as a legal thing on Nantucket. Now, we want to make clear that we know the town already recognizes, acknowledges, and supports the fact that STRs are legal on Nantucket. So this would simply be further confirmation of that fact. But we feel it could help to set aside lawsuits that we know have been very disruptive to our community, and we hope we can get past all that. So the zoning that we are proposing in Article 2 is primary zoning. It means that the use is a legal primary use. Article 2 would establish STRs as a primary use, and then bold print, but only if the STR obeys all the regulations set forth in Article 1. In other words, we know this is giving a big right or whatever, which already exists according to our town. But because it will be well regulated, we feel it is a responsible thing to do. It is not untrammeled. It is not opening the doors to everything. It is trying to use multiple regulations to limit and reasonably regulate STRs in the future. Now, here's the thing, though. What voting total in percent does a zoning bylaw need to pass? As we mentioned earlier, a zoning bylaw needs a supermajority. That's 2/3 or greater in order to pass. Now, as an example of this, I'm not going to editorialize on this, but in the FinCom version of the warrant, which is the one that's moving forward, if Article 1 passes and Article 2 fails, both will fail. And we personally think both articles are very important, but we know that 2/3 is a very high bar to reach. Sometimes when I'm in a room, I wonder if 2/3 of the people will agree that the world is round. I mean, I hope they will, but you know what I'm saying. It's a very high bar. And it does seem possible that even if Article 2 failed, if Article 1 were allowed to remain in effect, that the regulations would have a great benefit to everyone. However, that's to discuss, obviously, a town meeting. Now, this is what I've already said, this final one. If the zoning bylaw is passed, does that mean that untrammeled STRs will be allowed in every corner of the island? And no, only STRs that obey all the regulations set forth in Article 1 will be allowed. And as it's written now, if either Article 1 or Article 2 does not pass, neither article will go into effect. So it's the right, we think, is already recognized by town. This is reconfirming that right, but only in the context of reasonable regulation. Okay.
Thank you, Jim. I have a hand from Paul Flanagan.
Thank you. So my question is, if Article 1, the general bylaw, passes, then will these lawsuits of neighbor versus neighbor and against the town, do they go away?
I think I will, if it's all right, Brooke, I'll pass this on to John Giorgio, except to say that I think the work group feels that any reasonable regulations that are put into effect could only be a good sign to a judge deciding on a case that our town is very serious about doing this in a legal and reasonable way. But John really knows that answer better than me.
Yes, thank you, Jim. So, you can never guarantee anything, but I'm going to use that word anyhow. If you want to guarantee that the lawsuits go away, you have to pass Article 2. And Article 1, of course, because the issue in those lawsuits is whether STRs are a commercial use in a residential zone. That's the issue. If Article 2 passes, that they will be recognized allowed in all zoning districts, and that would, in our opinion, moot the current cases that are pending.
John, would it help if Article 1 were passed, but not Article 2, or would that not be enough?
Jim, I think it would help, but if you want to get rid of those lawsuits altogether, because it's still going to be up to a judge to decide passage of Article 1 is sufficient, and I'm not going to say that that a judge will find that necessarily, although that is what we're arguing. But again, the only real guarantee to get rid of the lawsuits is to pass Article 2.
Thank you. Okay, any other questions at this point in time?
Brooke, I just wanted to show people who are interested in the frequently asked questions that Jim just reviewed. They are on the website, on the town's website, under the 2023 special town meeting, short-term rental articles, FAQs, and they're all listed here. And when you click on the title, it brings you to the answer. So everything that was just discussed and outlined in that FAQ sheet is right on the website.
Thanks for that, Erica. It's pretty quiet out there. No question. I expected this to run a little bit longer, to be honest with you. So, but this is your opportunity for this evening to ask questions. Oh, there we go. Betty Ludke. Hope I pronounced that right.
Yeah, you were perfect. Can you hear and see me there?
We can hear you. We don't see you when you're an attendee, but please go ahead.
Okay. No, I had a question. I'm from the town of Barnstable and listening in intently because I think what you're doing is fantastic. And maybe it would be a model for some of us over here on the mainland. I know you had this come up or something, not this, but something earlier this summer that was defeated. What is your sense based on the vote there, the questions that happened? What is your sense that this one might be successful? Because to me, what you've explained here seems so reasonable and so positive and addresses the grandfathering and moving forward that I've got to think it has a great chance. But I just would like your sense on what happened this past summer and what you think going forward with this. Thank you.
I appreciate your question very much, Betty, and I'm going to not speculate on the mood of our town meeting. I think that you will understand that it depends on who comes and what perspective they bring to the discussion on the floor of town meeting. Hesitant to speculate. Sorry, unless if anyone else wants to bite that off. But I think we're going to try to avoid going down that direction right now. But thank you for the compliment on the process and the presentation, and I'm actually going to be attending a meeting in Hyannis in a few weeks. That is a meeting of communities on the Cape about short-term rentals, and Dave Iverson and I are going to be presenters at that meeting. There will be I'm sure it will be before our town meeting happens. So some of the conversation will be pretty similar to what you've heard here today. So Ralph Keith.
Yes, thank you. I have a question that falls back on just a few minutes ago. So if the town does not pass Article 2, does that make them responsible for the legal costs of homeowners that are sued? Because it's a good question, I think, that the town should be aware of.
Okay, thanks for your question. John, do you have any?
Yes, the answer is no. The town would not be legally responsible for those costs. You can imagine, well, the reason is because the town meeting is a legislative body and enacts legislative policy and is essentially immune from lawsuits because of that policy role that the legislature plays.
Thank you, John. Steve Cohen?
Brooke, I do want to say that just an aside, I really appreciate the prior person's comment that reason and merit are the basis of decision making. I hope that that is true. In my 18 years of doing this, it hasn't been the case, but I appreciate her compliments to the work that's been done here. So, you know, obviously I'm kidding, but the question I have, and it's not really my question, but I think that it's something that's likely to come up, and people have asked me this, so I'm curious if the town is working on it, is does the town have any idea of what the cost of enforcing this would be, of collecting this data, of regulating this way, and is there some kind of budget rider that would go along with implementing this, or is there a timeline on which that would happen? You know, just as someone who deals with the town quite a bit, I'm trying to imagine the amount of staff time and materials and equipment that would be involved in properly running something like this. And I just want to know if the town is going to be prepared to answer that question. Thank you.
Thanks, Steve. My understanding, and John, help me with the phrase, the fee structure for this. It's what's the type of fund?
It's a revolving fund.
Right.
Right. So the town is going to launch the registration process under under the Chapter 123, and there is a fee attached to applying for a certificate of registration. Those funds will be segregated and they're available to be expended for the purpose of administering and enforcing the short-term rental registration program.
So the fees can be scaled to cover the cost is
yes,
ultimately the impact of a revolving fund.
Yes.
Thanks, John. Hugh Lloyd Thomas.
Yeah, two questions, if you can hear me.
Yep.
First of all, there's always a conversation about island residents who rent their homes out, which allows them to afford to live here. What is the percentage of people who actually do that on the island? Is it a large number, a small number? Everyone always talks about it. I'd like to find out what that sort of an estimate of what that number might be. And then the second question, you talked about the definition of a natural person or natural people, and you referred to what's happening in Palm Springs and Great Barrington. How do they determine that these LLCs are in fact natural people and not just a whole bunch of natural people fronting as a corporation?
So I'm gonna take the first question to say that we don't have a lot of detailed data on short-term rentals as they exist in Nantucket. There is some data, but it's very limited. And when we passed Article 1, the bylaw, the original bylaw, the idea was that a registration of short-term rentals would allow us to collect a lot more detailed information about them. So we will know more going forward as this regulatory system is built out, to answer your first question. And then John or Jim, why don't you take the second one?
Can't give a total answer, but I had a long conversation with one of the enforcement officers in Palm Springs, and she said, yes, they are able to look at the certificate of incorporation, I believe it's called, Hugh, with an LLC, and they can actually trace it down. Now, I am sure there are ways to get around it. We are hoping that won't be a huge percentage, and we think it can be controlled. But they said, absolutely, we can control that. So they know more about it than I do, but I'm just passing on what they said.
And Jim, I would also add that under your existing Chapter 123, the Board of Health, with the approval of the Select Board, is authorized to enact regulations to implement the bylaw. And so that's going to give the town some nimbleness in being able to respond to situations where there's some kind of a shell going on or an attempt to evade the intent of the bylaw. We think we can address that through regulations, which rather than having to go back to town meeting and amend the bylaw.
So that is to say, if someone finds a workaround, we can amend the bylaw to address it.
Yeah, or even what I'm saying is enact regulations to address it.
Okay, great. Thanks for that clarification. Mike Herlihy?
Can you hear me now?
Yes, go ahead, Mike.
Yeah, I'm sorry, I was muted. This may be for John, and may also be for Brooke. There's a portion of language in the original warrant that I didn't see changed in the financial side that said that in order to continue to run short-term rentals, you had to have a rental in the prior year and continue to have a registration year to year, which normally would not be a problem in my mind, except when you reach a family circumstance where something legal is happening. Maybe there's some dispute over how the property is passed at someone's death, or maybe there's a divorce, or there's a medical emergency, or et cetera. How would that be treated? Or is that basically just you go to some review board for a special situation, and will they be given guidance to handle things like that?
So, John, do you want to try to address that?
Well, real quickly, Brooke, we included in the bylaw subsection N, which says that the select board may designate a town official or town board to grant a waiver from any of the provisions upon a showing that such a waiver is necessary in order to prevent an undue hardship. So there is a waiver provision that is being put into the bylaw. And there will be an opportunity for folks to apply to that board or official for a waiver based upon special circumstances.
May I ask John a clarifying question?
Sure.
John, the provision about showing that if you've rented that you've obeyed the regulations, is that there to mean that you must rent in order to continue to be rented? Or did it simply mean that if you rent, you need to obey the regulations?
That's correct, Jim. Yes.
So in other words, it's not there to say you must keep renting each year. It's just the way the legal language is written, but it doesn't have that meaning. And I'm sure John wouldn't interpret it that way. Yeah.
Okay. Thanks, Jim. Denice? You're muted.
Okay, actually, John, it says in terms of the getting a waiver, it's for paragraphs I through M, not paragraph H. So I don't know if that makes a difference. I just wanted to point that out.
Well, H is the grandfathering provision. M is, the 9 versus the 4 changes in occupancy. So I still think it's will be nimble enough to allow the town to respond to specific situations where a hardship exists.
I probably misunderstood Mr. Hurley's question because I thought he was talking about it had to have been rented at least once in the third quarter in the last 4 years, 2019 to 2023. That wasn't his question.
He was referencing a different section, I think, Denise.
Okay, thank you.
And if we've got that wrong, Mr. Hurley, please raise your hand again. Kathy Baird.
I just wanted to respond back to somebody asked a question earlier about how to cover the cost of enforcement. And so that was my what I wanted to cover. Since the town is looking to replace their vendor who is going to be doing the registry and the online portal, several folks were involved in the solicitation process and the evaluation process of that vendor. And so right now, the way the costs are, I think it's $250 for each STR that's registered. I think they're between, let's say there's 2.5 thousand of them. That gives us about $625,000 on an annual basis paid for by the fees. And it does not appear that the cost of the vendor would be anywhere close to that. And also the vendor will be doing a lot of the enforcement background checks, information on their own, because that's what they'll be paid to do. So it won't necessarily fall on town staff to do it. And some of the work could be done by town staff if that's the desire of the town to do that. But there should be plenty of money with even the existing cost structure to cover the enforcement of these regulations. Thank you.
Thanks, Kathy. That's very helpful. Okay. Any other questions out there? We do have a meeting scheduled again next Thursday at 5:30 p.m. to capture a different time of day for people. So if as you ponder this and you have further questions, you're welcome to join the meeting next week. And I also encourage folks to share the link to this video that will be online. It's the meeting link that you all clicked on to register. We'll take you to the YouTube video and share it as you're talking to people. If they have questions that you think were well answered this evening, I would encourage people to share that link or watch the recording. But people will have an opportunity to ask the same questions of us next week when we have the second session of this Thursday at 5:30 p.m. I'm going to suggest this is the last chance to ask questions. We're not going to keep the meeting open if the community's not engaging with us. So seeing none, I want to thank our panelists and participants, everybody for asking great questions, and encourage everyone to keep thinking about it. And most of all, please come to town meeting, special town meeting on November 7th, and join the discussion on the floor where we as a community, you as the legislative body of Nantucket, will decide on what happens with this warrant. So thank you all very much, and I'm going to bring the meeting to a close. Have a good evening, everyone. Charles?
Getting there.
Again. Thank you very much. We all get to go home early.
Can't complain.
All right. Have a good night, Charles.
You too.
Can you edit out my husband walking in the room?
No.
I'm just kidding. See ya.
Yeah.